Thank you, Chief Justice. May it please the court, counsel. This case has a long history, as this court knows. In fact, the very first time that I argued before this court was 6 years ago in Appellants 1. And typically, because the court's familiar with the history, I don't recite it, but I think in this case, parts of the procedural history are real important to the merits of the case. 10 years ago when this case started, or almost 10 years ago, plaintiff filed a suit under 29 U.S.C. 2617A2. This is important because that's the private right of action created by Congress to permit people to enforce provisions of the FMLA. It specifically permitted private rights of action against states. Here, the violations alleged were under the self-care provisions of the FMLA, which was also important. After a jury verdict against the defendant, this case went up on appeal in Appellants 1. This court, on further review, reversed the judgment, concluding, following the U.S. Supreme Court's case in Coleman, that when Congress passed that statute, they had not validly abrogated the state's sovereign immunity to suit under the 11th Amendment. This court, however, noted that notwithstanding the immunity that it found, that there could be a remedy under the doctrine set forth in Ex parte Young, and remanded to the district court with instructions to determine what relief would be available to the plaintiff in light of the court's ruling. The district court then issued a new judgment, a new final judgment, in accordance with the court's instructions, which really included two things. One was reinstatement, perspective, and then a money damages award that sought to reimburse plaintiff for the time off of work from the date of the judgment, the original judgment, to the date of reinstatement. That was appealed to this court. And in the second appeal, this court held that notwithstanding the immunity, and I guess there were predicate findings that are also important here, which is this court found that within the pleadings and the cases tried, that in fact plaintiff had made out a claim under Ex parte Young. And that the judgment, and the fighting issue was the money damages, and this court found, really following a case from the Eighth Circuit called Barnes, that because it was prospective and not retroactive, that the money damages didn't violate the 11th Amendment, and therefore judgment was affirmed. Today's case is the third trip before you, and today's case deals with the district court's order awarding attorney's fees to the plaintiff for the whole litigation, going all the way back to the trial, first appeal, second appeal, to now. It is up.
Getting to that issue, Mr. Thompson, I mean, you say the whole litigation. Am I correct? The state did not argue below that the court should award only a portion of the requested fees. It was kind of all or nothing. That's what Ms. Fiedler says, and you don't dispute that, do you?
Well, I think it was all or nothing on the immunity question and on the question of whether there's a mechanism, a statutory mechanism for the award of attorney's fees. And so we've argued that it was error for the court to award fees at all. Even under Ms. Fiedler's theory of fees, which we dispute and I'd like to talk about, which is a bootstrap. It's a three-step process. This is an FMLA case. FMLA under 2617A3 has a fee provision, and under Missouri v. Jenkins and other cases, that an award of fees under that fee provision doesn't violate the 11th Amendment because it's ancillary to prospective injunctive relief. But even under her theory, that those fees would have to be limited to the fees that were specific to achieving the prospective injunctive relief. If you read Hutto, you read all those, and so we did argue that that was inappropriate. I will concede, absolutely, we did not parse her fees in terms of hourly rate or the number of hours, but we made the legal argument that it was not appropriate under the standards that this court should apply as a matter of law.
Did you make that argument in your brief? I only see the ex parte Young argument.
No, there's an argument in our brief that says that the original orders should not be valid for two reasons, really, because they were reversed and never revived, but secondly, because they really don't
But that
follow.
that argument wasn't made in the brief, Mr. Thompson. The only argument I see is the ex parte Young argument.
Well, I have to go back. I'll look at it when I sit down, but I think that if you look at the discussion of Missouri v. Jenkins and the Hutto case, which is where this really, in fact, Ms. Fiedler's own arguments that quote from Missouri v. Jenkins use this ancillary language, and it's the legal standard, and so I think that argument is here. But our primary argument is an all or nothing argument, which is there is absolutely no legal mechanism that permits the award of attorney's fees under Iowa law or any law in this case.
Is your alternative or backup argument that we could order, if we rejected your first argument, we could order on remand the district court to only, or to limit the fee award to only those involved in securing the prospective injunctive relief?
It is. If this court chooses to follow Missouri v. Jenkins and the line of cases that deal with Section 1988, which isn't before you, that's the standard. But that is not what's before. This is not a Section 1988 case, and all the cases that deal with Section 1988 are distinguishable because this statute is different. This statute is different for a number of reasons. Number one, the application of the statute is different because, as I just said, the lawsuit started with a private right of action brought under 2617A2. They rely on 26A3 as a mechanism for attorney's fees, and structurally, as a matter of interpretation, this statute bootstraps and requires that in such an action you may recover fees, and this court has found that there is no such action, that we are immune from such an action.
Well, you are immune from a damages claim. Go ahead.
Oh, yeah, well, I don't agree with that. I mean, I think that's, I mean, there's a lot of loose language in 11th Amendment cases. 11th Amendment is immunity from suit. And the reason that the damages language starts to come in is because of the longstanding recognition under Ex parte Young that there's an equitable remedy and that prospective injunctive relief against official capacity person can be brought. And so that's why we talk about damages, but what this court, I'm sorry, go ahead.
You know, we're on beam. You're helping me. But there was a limited recovery in this case. It included injunctive relief, and it included the payment of a monetary sum. The substantive legal basis for that recovery is what?
I think it's two things. I think Ex parte Young is an equitable action. If you go and read the old case, and thanks to the Minnesota Attorney General, we have an interesting case. But it was an action in equity to enjoin a state official, and that created this argument that this really isn't a state a suit against the state. And so that's the mechanism, and it's a well-recognized mechanism. The damages provision, the damages award, in Tina Lee 2 that was upheld, was really this court adopting Barnes's analysis under Edelman of the prospective versus retroactive line for Ex parte Young, and just saying, hey, because there was a judgment on this date for reinstatement, and she ultimately prevailed on reinstatement, and because of the stay argument that the court made, that this award of damages just was in support of, or ancillary, I guess, to the prospective injunctive relief. So it's not under the statute.
Mr. Thompson, can you tell me action that would be successful under In re Young that is not founded on another federal statute? I mean, you have any example where someone brought a case under the doctrine of Young and didn't have another federal statute as the basis for either defining the remedy or defining the wrong?
Well, the basis, I mean, it depends on what you mean as the basis. Ex parte Young is the equitable power of a court to tell you you should follow the law. That's different than a remedy arising under another statute, which is the argument that they're making.
But as you said, it's the equitable power of the court to follow a law. So, you know, when can you ever bring an ex parte Young case when you don't have a violation of another federal law? I mean, tell me how they're different.
Well, I don't disagree with the last statement you made. I mean, there's a violation of a federal law, and you can enjoin an official to stop the violation or to follow the law. But that's different than creating a claim for the violation, a retroactive claim for the violation of the law, which is what,
the state's position is that if you bring an injunctive relief to stop somebody from violating the law, and that law provision has an attorney fee provision, it doesn't apply. And what's the authority for that?
Not always. I mean, because this is a question of statutory interpretation. And so if you look at Section 1988, which is what all the cases cited by plaintiff rely upon, and 1988 is this broad statute that sweeps in all the civil rights laws, and frankly, the Congress could have plunked FMLA in the 1988 statute. They chose not to. They created their own statute that is hooked to the right of a cause of action. But under 1988, and in the Hutto case, any action brought to enforce any statute that's listed in 1988, even if in an ex parte Young equitable action, according to Hutto, can entitle you to a recovery of prospective attorney's fees. I mean, that's what
When
Hutto
did the state,
says.
Mr. Thompson, recognize or understand this to be a claim for equitable relief?
I would, yes, but it would be a claim for equitable relief at equity, not under Section 2617. I mean,
Well,
the right of action referred to in 2617A3 points back to 2617A2, which this court agreed was not a valid abrogation of state sovereign immunity. So it doesn't apply, and it requires, there's this predicate argument that there has to be an award, but yes, I think you can try and follow the path.
well, what point in time is the state, you said that this is a claim for attorney fees that goes back to the beginning. At what point did the state see this as not a claim under the federal statute, but a claim for equitable relief to which attorney fees would apply?
Well, from our perspective, it changed when this court dismissed the legal claim that was brought under the statute and then essentially directed the plaintiff to ex parte Young and remanded to the court to permit the plaintiff in the district court to reformulate the case. And so we argued below.
Well, what was done then what was reformulated when it went back to the district?
Well, what happened was although there was literally a motion for leave to amend, which was denied, which is interesting, but I think this court has, in Tina Lee 2, determined that the pleadings that were before the court, when it went back on remand, that under the notice pleading standards of Iowa, that the right party was there and the right claim was made, and therefore that if you, in the light of Tina Lee 1, read this and treated this as an action under ex parte Young, that they could obtain relief. And in Tina Lee 2, this is the other important thing about, is it an FMLA case or is it a ex parte Young case? On the second decision that was written where you affirmed the prospective relief, the reinstatement and the money damages, you said under ex parte Young. It doesn't say this is an FMLA award. because that provision, the private right of action, this court found was not a valid congressional attempt to create a private action against the states. And the attorney fee provision here is embedded in that, as opposed to Section 1988. Again, all those cases have a different provision for fees that incorporated, and the Hutto case even found that it's so broad that Congress intended, both in its language and its congressional legislative history, to embrace ex parte Young injunctive relief actions against official capacity actors. I mean, that's the mechanism. Congress could have dropped FMLA right in 1988, and we wouldn't be here. So, and I've run out of time.
Thank you, Counsel. Ms. Fiedler.
Thank you. May it please the court, counsel. No court has ever ruled that a state is immune from having to pay attorney's fees. In an FMLA case, and as far as I know, no court has ever ruled, period, that a state is immune from having to pay attorney's fees in any kind of fee-shifting case. On page 9 of their main brief in this action, in this appeal, defendants assert that the sole issue before this court is whether there is a statutory basis for the attorney's fees that were awarded in this case. That's the sole issue, and that sole question is answered very easily. The statutory basis is the Family Medical Leave Act, specifically 29 U.S.C. Section 2617A3, which states that in addition to any judgment awarded to the plaintiff, the court shall allow a reasonable attorney fee to be paid by the defendant. The defendants continue to try and say that this case can only be an ex parte Young case or only be an FMLA case, and that the two can never...
I'm not sure you're giving Mr. Thompson's argument full credit. Let me try and phrase what he's saying or rephrase what he's saying and tell me if I'm right or wrong. As I understand his argument, you have a civil remedy provision under the FMLA that includes attorney's fees.
Correct.
His argument is, we said in Lee 1 that states are immune from that civil remedy provision. All you can get is ex parte Young relief, which is essentially equitable relief to prevent the violation of a federal statute. So his argument is under that alternative, that ex parte Young relief, you can't go back and borrow from the fee provision in 2617. So what's wrong with that argument?
Mr. Thompson does not accurately state the holding of Coleman or this court when he says that those decisions gave the state immunity from suit under the FMLA. That is not the holding. The holding is that under the self-care provisions of the FMLA, the state is immune from money damages. That is the holding of both this court's ruling in Lee 1 and the Supreme Court in Coleman.
Well, I'm not sure that's his argument, frankly, but he can make his own argument. I'm sure he will when he comes back up. What he sees, I think, and we all admit that there's an interrelationship between ex parte Young and the statute. I mean, and the question is, are they inextricably intertwined, or are they kind of separate? And I think it's fair to say Mr. Thompson says, look, this is an ex parte Young claim. And yes, it's related to the FMLA, of course, but it's an ex parte Young claim, and you don't get attorney's fees for ex parte Young claims, even though the substantive basis for the injunctive action might be the FMLA. And you, of course, say, well, no, that's nonsense, because the basis for the ex parte Young claim is the FMLA. Frankly, I can see both characterizations of it. I'm kind of curious what the case law is on. I mean, there's been a lot of ex parte Young claims. What do you think is the highest? What case law would you direct us to and share us the reasoning behind it that suggests you can recover for equitable relief under ex parte Young?
Well, I cited, I'm going to say at least 4 cases in our brief, which the attorney's fees did not arise under Section 1988. The attorney's fees arose under the Age Discrimination in
I
Employment
know, I'm
Act.
not sure that answers the question, though. I mean, I understand those cases, but, and correct me if I'm wrong, because I may have a misunderstanding, but the fundamental issue that I'm grappling with is equitable relief under ex parte Young. Does that entitle you to attorney's fees under a statute where the statute itself doesn't give you the ex parte Young type relief? The statute, or the relief is really arising under our common law remedial approach to the statute.
There's 2 points to your question, Justice Apple. One is that the statute in question, the substantive statute in question, does not give rise to a claim for equitable relief. And I'll tell you that premise, in my opinion anyway, is completely false, because the FMLA does give rise to a claim for equitable relief. Secondly, the cases I cited under the it's IDEA, it's the education statute, the ADEA, and 2 cases under the FMLA. All of those cases are not subject to 1988. The attorney's fees provision is within those statutes themselves. And within all 4 of those cases, the court said, yes, of course the plaintiff gets attorney against the state, because the immunity provisions, the immunity doesn't apply, just like Hutto and Teobald and the other cases all held.
Did the fee award here cover all your fees, or did it limit it to those incurred getting a reinstatement?
It covered all of those fees.
Is the state entitled as an alternative, or could we find that that you're only entitled to fees for part of your case, for the part you won?
The only way this court could hold that is if this court decided there was no need at all for the state to preserve error. At the district court level, and as someone pointed out, even at this court level, the defendant has not really argued that the fee award should have been different. I will cite you to page 13 of the transcript of the hearing, appendix page 90, and the defendant said to the court, "We haven't submitted any specific objections to the specific portions of the bill. It's the gist of our argument and the focus of our argument here today that there's no mechanism to award the payment of attorney's fees in this case." They specifically denied having problems with portions of the bill. They don't get to come and appeal now and say the court should have somehow, gone through and parsed out the bill itself.
The relief they asked for in their brief is somewhat ambiguous. It says, for reasons expressed above, because there's no statutory or contractual basis for the award of attorney fees, the state respectfully requests the district court judgment be reversed. That could mean reversed in total, or that could be reversed as to the fees that aren't there. I mean, I think you could read it either way. Why can't you?
Even if you could read that as saying that district court award should be amended rather than reversed, the substance of their brief does not argue which portions of the attorney fee award were improper and which portions were. There's black letter case law that says it is the burden on the defendant in a fee-shifting case to point out the exact portions of the bill that they think are wrong.
Don't you think the substance of their argument is these were all reliefs for In re Young, and none of it's compensable, and the only thing that and then you're arguing what's compensable is the fees for the prospective relief. You don't cite any cases for the proposition that you get badly awarded attorney fees, if they are badly awarded.
But I don't have any duty to cite to cases to refute an argument that wasn't made, Justice Wiggins.
But isn't their argument, isn't the state's argument, doesn't it subsume, when they argue you don't get any fees, doesn't that subsume that you don't get fees for litigating the money damage award that was taken away? I mean, I agree with you that it's too late for them to parse it out, and you didn't need 2 lawyers at that hearing, or you spent too much time on that brief, or your hourly rate's too high. But their argument is you don't get fees, period. Doesn't that include you don't get fees for claims that were ultimately rejected, such as the money damage award or emotional distress, et cetera.
Well, I didn't make a claim for emotional distress, but at any rate, the fundamental provisions of the Due Process Clause require that in order for this court to award a relief, the defendant has had to argue for it, and I've had a chance to tell you all the case law that supports the fact that you should award fees for the whole thing.
Well,
And
I'm
I
more
haven't had a
interested-
chance to do that because they haven't made that argument.
Would the factual record have been different if they had made a more, shall we say, focused argument below?
Well, perhaps.
I mean, supposing they would have actually gotten their hind legs and said, look, you don't get money for the aspects of the fee claim that you were unsuccessful on.
And I can promise you, at that point, I would have put forth case law and other
I'm
authority.
not worried about the case law. I am worried about I am worried about the case law, but I'm most worried about factual presentation. I mean,
Sure.
I think, frankly, preservation of error can be kind of a tricky issue. To what extent is the argument a little different, whatever? But one place that's just absolutely core is that if a party fails to alert the opposing party to a claim that would have affected the factual record below, there's going to be big waiver problems. Okay, and so the reason I'm kind of drilling down here is what difference would it have made on the factual record on the attorney's fees issue if you would have had a specific claim that doesn't belong?
Well, I would have pointed out that the standard is what a reasonable attorney would have done under those circumstances. And when this case started in 2004, the only case law out there, I'm not even sure if Hibbs had been decided yet, but I think it had, and Hibbs said that the Congress did validly abrogate immunity on an FMLA claim involving the care of somebody else. And so it was certainly a reasonable argument for us to make.
I mean, I have no question you did a good job of representing your client in this case, but if you know, and I have a serious error preservation question as well, but it seems to me that if you can't get damages against under the FMLA because the state is immune, you shouldn't also be able to get attorney's fees relating to attempting to prove damages claims. It seems like that's kind of the tail that goes along with that dog. Am I wrong about that?
No, I see your point, but you also are entitled to get attorney's fees for your efforts to get equitable relief. And the underlying substantive law on attorney's fees says that you're able to get attorney's fees for even work on the case that was not successful or that was not on a successful argument, so long as your actions would have been reasonable for an attorney to do at the time.
Can't that all be sorted out if we buy your position, but say we're going to have to remand it for the district court to sort that all out?
I believe that is fundamentally unfair and a violation of the Due Process Clause, because then they get a second bite at the apple of trying to prove all these things all over again. In addition, Your Honor, my prediction is that we would be back here in 2 years.
But we like seeing you every 2 years in this case.
Well, perhaps I could work on another case and be back here for that. Let me just conclude. The defendant's sole argument at the hearing below was that attorney's fees were money damages, and therefore they were not allowed by Coleman and this court's previous decisions. And all four of those Supreme Court cases on point that we've cited in our brief address that issue and make it very clear that attorney's fees are not money damages. They are relief that is equivalent to the costs of an action that's ancillary to the relief that the plaintiff did get in this case. If the court has no further questions, we would ask that the judgment below be affirmed and that this court either award appellate attorney's fees or remand the case back to do so. Thank you, Your Honors.
Thank you, counsel. Mr. Thompson, rebuttal?
Yes, Your Honor. Briefly. Let me begin just by pointing, for example, to page 14 in our brief where we concede that the Supreme Court has recognized that attorney fees and expenses may be considered, and that it is limited to those incurred in seeking prospective relief, and that in this case, she seeks reimbursement for all of her expenses. I mean, that's one of the arguments we made as a basis for legal error when the court awarded what the court awarded, on a legal basis, not a factual basis. We're not arguing with her rate or her hours. It's categorical, it's legal. And I'll say again that every one of the cases, Missouri v. Jenkins and all those cases specifically do say two things. One is that, in fact, in Section 1988, Congress did abrogate the state's sovereign immunity, which is interesting. We don't have that here, which is why it's different than 2617. But then they go on to say that, for totally different reasons, that an award of attorney's fees essentially as costs under 1988 does not offend the 11th Amendment. I say that because one of the things that's important here is that in Tina Lee 1, the first case that came up, this court reversed the district court and said, go back, because those things that are not injunctive, prospective injunctive relief, cannot stand. And go back.
Can I interrupt you for a second? I mean, you cite on page 14, your brief is sort of cryptic here in this regard, but in your conclusion and demand for relief, you only ask for the judgment to be reversed, not modified.
That's true. That's the relief we seek, is we think as a matter of law there is no basis for fees. Now, that doesn't limit your ability if you're going to accept an argument that 1988 case law, which shouldn't apply, that you're going to apply and adopt that standard, which essentially is what she's arguing for you to do.
We could always say
you can't remand for
we could
findings.
always say it wasn't preserved and we're not going to address it. We don't have to find it.
You could do that, but you're not compelled to do that. And I just find it ironic to talk about due process and how fair this is to not lose sight of the fact. And the chief said it best in dissent in Tina Lee 2, but last time I was here, because we didn't argue the second case, we won. We won, and this court taxed costs. This is back to the 1988 cases, taxed costs against the plaintiff for that appeal.
Let me just clarify this for my simple mind here. Your appeal in this case basically is that none of these attorney fees should ever have been awarded because there's no statute or case or anything in the world that would allow attorney fees to be awarded. But if we do find that they can be awarded under FMLA, we need to pare down those damages to only those attorney fees that only were related to injunctive relief. Do I have that right?
That's what you
and
should do.
That's the sole purpose of your appeal.
No, the sole purpose of my appeal.
I mean, the sole relief you're asking for is what I'm saying.
Well, yeah, I mean, we're asking you to reverse and vacate the district court because there's no mechanism at law, and this court has always applied the standard there has to be a statutory basis. And so in all these cases, all these ex parte Young cases where you find fees, you're going to find chapters 1988. Because everyone that's cited does that. They find different ways, but they're prospective injunctive relief cases, they're 1983 cases, they're ADA cases. I mean, Congress knows how to put statutes into the laundry list of things under Section 1988, and they haven't done it with the FMLA. There's a standalone right of action, which this court and the Supreme Court has found was not a valid act of Congress under the 11th Amendment. And so that's the sole basis that
How
they're
do you
arguing.
distinguish the cases that counsel talked about that provide relief under other acts?
I have no idea
Ray
what
Young.
she's talking about. I'm not aware. The laundry list of cases, there are two cases that they cited in support of FMLA. One is a magistrate's order on a motion to dismiss, and one is a district court's denial of a defendant's motion for summary judgment that just lets a case go forward. So there are 0 cases that support the proposition that this now unconstitutional provision as applied to the states can be used as a basis for attorney's fees in an ex parte Young action. In the end, Iowa law, which you would apply, requires a statutory hook for attorney's fees. There is no statutory hook here. FMLA doesn't provide it. 2617 doesn't provide it. Section 1988 doesn't provide it, and if you look at all the cases that they're relying upon, they're asking you to apply that. If you choose to adopt that as a standard, then at least hold her to that standard, which is ancillary to prospective injunctive relief. Thank you.
Thank you as well, counsel. The case of Lee versus State of Iowa is now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.